Assalamualaikum and hello everyone. Today I am going to discuss about the case which is Hyde versus Wrench. Hyde versus Wrench is a leading English contract law cases on the issue of counter offers and their relation to initial offers. In it, Lord Langlet ruled that any counter offers cancel the original offer. So it is this case is basically deals with the fact about counter offer of contract clause. So we are going to know the quick facts of the cases. This case is from the Court of Rose Court and it is from 1840. So the fact of the case was Range offered to sell his firm in Ludenham to Hyde for £1,200. Range is the defendant of this case, and it was an offer which Hyde declined. On 6th June 1840, Range wrote to Hyde's agent offering to sell the firm for £1,000, stating that it was the final offer and that he wouldn't alter from it. So basically the main point actually started from on 6th June 1840. Because it was the final offer from Range. Hyde offered £950 in his letter by 8th of June, and after examining the offer, Range refused to accept and informed Hyde of this on 27th of June. On 29th, Hyde agreed to buy the firm for £1,000 without any additional agreement from Range, and after Range refused to sell the firm to him, he sued for breach of contract. So what was happened is Hyde actually offered a counter offer by stating that he wants to buy the firm in £950, which was a counter offer in regard of the original offer was £1,000 from Range. So the original offer was altered by stating the new offer, which was £950. And after that, later on, Hyde actually agreed to buy that firm in that stated 1,000, that final stated price from Range, which was £1,000. But Range refused to sell the firm to him, and therefore Hyde actually sued for breach of contract. This was really interesting thing because this is really interesting because there was counter offer, and later on Range refused to sell the firm with that original price. The judgment was very accurate, and which was, under the circumstances stated in this bill, I think there exists no valid binding contract between the parties for the purchase of this property. The defendant offered to sell it for £1,000, and if that had been at once unconditionally, there would undoubtedly have been a perfect binding contract. Instead of that, the plaintiff made an offer of his own to purchase the property for £950, and he thereby rejected the offer previously made by the defendant. I think the judge Lord Langdale's thought that it was not afterwards competent for him to revive the proposal of the defendant by tendering an acceptance of it, and that therefore there exists no obligation of any sort between the parties. So this was mainly dealt with the counter offer thing, and what was stated in this case reference, and why we have to know this case judgment, and why is it really important under the contract law case precedents, because it dealt with the counter offer, and counter offer actually cancels the original offer. This was the main purpose of this case. So I hope it will help you guys if you're watching this, and I hope if you have any suggestion or comments, or if something went wrong, please let me know. under the comment section. I'll really appreciate if you do this. Thank you so much if you're watching, and have a good day.